My presentation is about the lessons which foreign investors must or better learn from the ICSID Arbitration Tribunal Award of 4th October 2006, the Honorable Justice Retired Togbos Arbitration Award of 5th December 2012, and the Honorable Justice F. Tuyot's ruling of 5th October 2018 regarding a dispute between World Duty Free Company Limited and the Republic of Kenya. The predecessors of the World Duty Free entered into an agreement in 1989 with the Republic of Kenya, giving WDF exclusive rights over duty-free shops in Kenya's international ports, that is, the one in Nairobi and the one in Mombasa. The two parties subsequently entered into several other agreements as well as leases for specific premises. Those agreements were all based on the initial 1989 agreement. The leases expired and were duly renewed in 2003 under a court order. A dispute arose and was referred to the ICSID in accordance with party agreement. Mr. Nasir Ali of WDF told the ICSID tribunal that his company procured the 1989 concession with a personal donation of US$ 2 million to President Daniel Arap Moi of Kenya. The ICSID three-person tribunal found that the payment was a bribe, which was against international public policy, and on 4th October 2006 dismissed all claims against Kenya. WDF, instead of commencing annulment proceedings, which are provided for in the ICSID regime, started a new arbitration in Kenya. The then Chief Justice of Kenya, in his wisdom, appointed Honorable Retired Justice Edward Togbo, who had just retired from Kenya's Court of Appeal, to arbitrate the dispute. Kenya boycotted that arbitration on the day of the scheduled hearing and did not cross-examine all the claimants' witnesses, and also did not present any witnesses or file any written submissions. The Togbo Tribunal found in favor of WDF. Kenya subsequently applied to the High Court of Kenya for the setting aside of Justice Togbo's award, and the decision was made by Justice Tuyot of the High Court of Kenya in October this year. So, what are the lessons learned, or which should be learned by investors in this matter? Lesson number one is that corruption at conception of a transaction swells the entire investment throughout the life of the investment. The 1989 agreement, which was the only one on record as having been procured through corruption, was the basis of all the subsequent agreements. And so, corruption at procurement and inception swells the entire investment. Lesson number two is that courts look at the entire picture over the life of an investment. WDF pleaded with Justice Toyot to treat the 2003 leases as new contracts which were not tainted with the 1989 bribery. The judge was not impressed with that argument any more than the ICSID tribunal was. Lesson number three, corruption in the afterlife. Because the initial leases had expired WDF had hoped that the renewed leases of 2003 would be treated differently. But of course, the Exit Tribunal and Justice Tuyot again refused that argument. Lesson number 4, the wizard expert witness. WDF submitted to the Exit Tribunal an expert report in which a leading Kenyan sociologist, Dr. Pius Mutie, opined that gifts like the one which President Moi received was given as a way of saying hello to the president. He added that it would be an insult to the African people to describe such philanthropy as corruption. Needless to say, the Exit Tribunal may have been amused, but it was not convinced that Ali and Moi had in 1989 become such close buddies that exchange of $2 million could be considered a token of appreciation or just a greeting. Point number 5, or lesson number 5, is the myth of unlimited investor protection. Customary international and also customary international law and the bi- and multilateral investment treaties exist for 2 reasons. Firstly, to attract foreign investment, and secondly, to protect the investment by restraining host states from unlawfully interfering with or terminating or confiscating such investment. World Duty Free apparently believed that the protection was unlimited. Yet the same customary international law and specific treaties have put some limits. Hopefully, foreign investors have learned the lesson that the Exit Tribunal and which Justice Tuyot of Kenya have expressed so simply in their decisions, and which World Duty Free and its esteemed advisors seem to have ignored. Lesson number 6. A reading of the Exit Award and the Arbitration Award by Justice Togo and the ruling by Justice Tuyot of Kenyan High Court all give the impression that Kenya evicted World Duty Free from the subject premises forcefully and without due process. Yet WDF is left completely without a remedy because of corruption in the 1989 agreement. The jurisprudence on effect of corruption and illegality on parties' claims is quite complicated, especially when one throws in unjust enrichment. The WDF case is certainly not the last word. All the same, it is safe to say that an investor who engages in bribery and corruption at any stage of a transaction exposes the investment to great risk. Lesson number 7, reputation damage. Any investor who or which has a reputation or brand worth protecting in this global village should not engage in corruption. 8, lesson number 8, I've titled this, Of Life Precedents. A corrupt regime protects itself from exposure through state machinery. This particular scandal would not have been exposed if Moi had been a life president. Regime changes expose corruption if only to popularize itself among the masses. I've added that because sometimes the fight against corruption is quite political. In the case of the transition between Moi and Kibaki, of course, Kibaki exposed a lot of mischief in the earlier regime, but his regime was not free of mischief, if you remember the agro-leasing scandals. Number 9, lesson number 9 is that states are watchful, ziko macho. Although states complain a lot about ISDS, they in fact win very many cases. In addition to WDF, Kenya has also won the Codec case at ICSID, and by the way, Justice Togbo was an expert witness in that case. And Kenya has also won the windmill case, and of course, the good old Kenren case from the 70s. So Kenya just keeps winning these cases. It's just like the marathons. The marathons make headlines everywhere, but not in Kenya. We are used to these things. Lesson number 10 is that Kenyan courts are awake. Why did WDF commence a new arbitration in Kenya instead of subjecting the ICSID award to annulment proceedings which are available in the ICSID regime? Now you know from the horse's own mouth how WDF operates. Maybe it was betting on enforcing a favorable arbitration award from a different forum through a friendly judge in the Kenyan High Court. Wrong move, which backfired with massive noise in the form of costs. Epilogue. Hopefully, the admittedly unholy ghost of the world duty-free scandal will now rest in pieces and never rise again, courtesy the ICSID Tribunal and Justice F. Priot. Thank you very much.